Café. This is a show brought to you by the Office of the Director of Public Prosecution. It takes place every Friday on Facebook Live at 8. Feel free to engage with us on Facebook. We are also on Twitter. We are also on YouTube at the Office of the Director of Public Prosecution. We welcome you to subscribe. You are also welcome to ask any questions on Twitter and on Facebook. We have a team of experts on standby who are waiting to respond to your questions as pertains this discussion today. We engage, we want to inform you, we want to educate you about different nuances of the criminal justice system so that you're able to apply it in your daily lives or as you may see fit. So welcome, because knowledge is power. Let's all go on a journey of empowering ourselves. A quick sneak. You remember we also just tell you what is happening in the courts, just a few cases. Our first case is on the former Nairobi Governor Sonko, pushed forward to April 19th. Because of COVID, the new measures that were announced so that the actual court sessions were suspended. So there's a new way this is going to happen, and it's going to take place from April 19th. Remember, Sonko has been charged with corruption, one of the many cases against him, and this one is going forward. So stay tuned and just keep following up on this case. The next case really caused an uproar on social media, and I believe it still is. It's on SGBV, and it's about Velvin Nungari. Remember, if you're on social media, you know how people went crazy about these cases. People took different sides, but the law is still the law. And Joseph Murimi, the guy who was with Velvin on that day, has been charged with murder, and he's to answer to these charges. He has been released on bail, 200,000 bail, and he's been asked by the court to report to Thursday. So the case is ongoing. He's out on bail though, but let's also just stay tuned and let's watch this and let's see how this plays out because a lot of people are interested in this case because of the rising cases of SGBV. The last one we talk about today is about a former cop called Nyamohanga. Nyamohanga faked his KCSE certificate, and this got him a job as an administrative officer for 14 years. So the case against him is that he earned a salary for 14 years on a fake certificate. So he was found guilty. He's been charged with a fine of 500,000 Kenya shillings or face a 2-year jail term. Those are the cases we had today. I know a lot of things happened in the courts, but those are the ones we picked for you today. We didn't have Semana Prosecutor today. It's a segment you normally have every other week on community engagement. This is just because of the new COVID measure, so we didn't go out to seek people's views on this. So today's discussion has been ongoing on social media, and it's about plea bargain. And I'm inviting you to join me on this journey, and we learn. Like, I'm also learning a lot of these terms in law, and they're very interesting. So previously, and actually, it is actually a right. What is it called? The right to a fair trial is guaranteed in the Constitution. Today, we want to discuss the alternative to that. We're not saying trials won't go on, but you're saying there's an alternative to it. We are saying the system is overburdened, prisons are full. So what is the other course of action? What else can we do? And we are going to discuss this today on our show today. I'm joined by two very learned friends, and I'm going to give them a chance to introduce themselves. First, Gikui.
Thank you very much, and thank you for inviting me. My name is Gikui Wangoigeshohe. I'm a prosecution counsel. I currently head the homicide division at the Office of the Director of Public Prosecutions. I've been a prosecutor for over, I think it's coming up to 10 years now.
Wow.
Yes.
Yeah, good. Karibu to the show.
Thank you very much.
We use this show to educate people and inform. So today you're a teacher of the law. JV, Karibu.
Thank you very much. Jambo, everyone. My name is Victor Juma Owiti. I am a prosecutor as well. I am in the Department of Emerging Crimes, but specifically in the Division of Anti-Corruption. I am here to enjoy the show and discuss with you on plea bargaining. I have been a prosecutor for like 7 years now. Yes.
Oh, good.
Since 2014.
Oh, good. Yes. Karibu sana. You'll hear me refer to JV, to Victor as JV, because you've heard his name is Juma Victor Owiti. So in short, it's just JV. So guys, karibu sana to the show. Like we said at the beginning, this show is meant to educate people. It's meant to teach people and to see how we apply the law. Kenyans are very, we love learning. I think we're one of the most educated, or we are interested in education. I think one of the most educated in Africa. So this show is one of those that we want to take people on a journey to learn. So I'll just go right into it. And maybe again, ladies first, Koi, what is plea bargaining?
Plea bargain is not a new concept. It's just something that has been formalized into our system. It's a negotiation that occurs between the prosecutor and the accused person in that has evolved. The accused person or the prosecutor can initiate plea bargaining. Once they reach an agreement, they then take that agreement to the court. The court can accept or reject the plea bargain. So it's a process where we are encouraging people to, instead of going through the full trial, they actions, they're able to tell people, yes, I'm the one who did this, and I'm willing to take the punishment as involved.
Yeah, okay. You know, we watch a lot of courtroom dramas, and we only get to hear plea bargaining on what? Law and Order,
Yes.
and all those. And I think there's even a new show in Kenya where I think we are going to get a lot of these terms, and people would really like to know what are the misconceptions, JV? What is, well, Koya has talked about what plea bargaining is, but definitely there are misconceptions around plea bargain. So what is it not?
I think the greatest misconception of plea bargaining is that it could be a deal-cutting mechanism where a prosecutor and a criminal sit somewhere, they cut a deal, the prosecutor is paid, and then he sets the criminal free. But that is incorrect. Actually, plea bargaining is, as my senior has indicated, entrenched in the law, and there are mechanisms to ensure that it is properly done within the four corners of the law. For example, it is entrenched as part of our constitution under Article 159 for alternative systems of setting out matters. It is also under our criminal procedure code under Article 1, under Section 137A to O. So the prosecutor is also obligated under Article 157 to ensure that whatever he does, including plea bargaining, promotes the rule of law, ensures that there is no abuse of the process, and that there is a fair administration of justice. So plea bargaining basically promotes justice. It is not a way to cut deals.
So
and the prosecutor is not paid. There's no money that goes to the prosecutor's pocket directly from the criminal. And again, we are bound to also consider the interests of the victim. So where the victim is going to be prejudiced, then plea bargaining under Article 159 to 3 will not be allowed to proceed.
Okay, just for clarity, you said it doesn't set the criminal free, does it? They'll still face the law.
They still face the law because they have to plead guilty, but thereby taking responsibility for their acts. This is how plea bargaining generally operates. There may be 10 offenses that you face as an accused person. Then in our arrangement, you agree to plead to 6 or 5. And as a way of giving back, we also say that now that you've agreed to plead, take away the other 5. But you, on the condition that you have to plead guilty to the 5. Alternatively, there's also plea bargaining where we have charged you with a very high offense, like say murder. But because you've also seen the available evidence, you're likely to be convicted. You decide that I will plead guilty, but to the lesser offense of manslaughter. Or finally, you are charged with an offense that attracts a very long sentence. But we agree that you'll plead guilty on the condition that we will make a recommendation, because the power to decide what sentence to give remains with the court. So we only recommend to the court that if he pleads guilty, we are willing to recommend this number of years if the court would be agreeable.
Good. So this thing is in the constitution, a new concept, and maybe that's why we're educating people here. So maybe just some history on plea bargaining. Where were we before, and where are we headed right now?
Right. The plea bargain process in Kenya started in 2008, where we entrenched plea bargain in our Civil Procedure Code, 137.80, as JB has said. In 2000, the DPP then started making rules, because that was what the Section 137 said, that the DPP will make rules. So these rules were finally gazetted in 2018. Is it 2014, 2018, I think. And then we did the guidelines in 2019. We have formalized the process. We have policies for prosecutors. We have guidelines for members of the public and members of the bar and bench. And what we are seeing is that although we have all this information as prosecutors, no one else has as much information as us.
Yes.
The victim does not understand where his role is, where her role is. The lawyers are not understanding how to initiate or how to go through the process. The accused person does not know how to even where to begin. He doesn't even know these things exists. So that's where, in collaboration with partners, UNODC and USDOJ, we have made various pamphlets and brochures, and we had started the process of going to each region to educate our prosecutors, to encourage them to also go back and educate the people on the ground, to educate our partners, our law enforcement partners, like people in the prisons, the paralegals, the children officers, the probation officers, the police officers, and then after to the NGOs, the people who are involved with the accused persons on the ground, the people who take care of the sick, the mentally ill, those kind of people. Because this plea bargain can only work as a concept if everyone is on the same page.
On board, yes. Yeah. So are we trying to put an end to a full trial, JV?
Not really. There are circumstances where a full trial will be necessary, especially where entering a plea bargain would be repugnant to justice. Those are the words used in the law. But there are also circumstances where it would be uneconomical to put resources in terms of the human resource, the prosecutors, the time, the judicial time, into a case where the end can really be seen from the start. And therefore, using plea bargaining would save us all that resource, would also help in easily decongesting our prisons, reduce the weight and the pressure, the backlog of the cases in court, and as well also help to easily reintegrate such criminals or suspects back into the society.
Okay. So does it apply to all cases? What cases can go for plea bargaining? For what cases can you go for plea bargaining?
That is a very contentious issue. Even in the judicial arena, there are those that are rigid and are of the view that some cases I don't touch, including sexual offenses, including murder. There have been where we have had a few cases, including murder, subjected to alternative justice system, where families or societies, like in northern Kenya, have come and said, we have ways of dealing with such circumstances. And once in a while, where the circumstances do not lead to repugnance of justice.
You have to break that down, JV. You can't say repugnance of justice.
What I mean is where the parties themselves, like the cases I'm making reference to in the northern Kenya, have come and said that we have a mechanism, a customary mechanism of dealing with such cases.
Traditional methods of conflict resolution.
Yes. We have paid this number of camels. The family of the victim have accepted. In very few rare cases, the DPP has accepted such pleas. But that is rather the exception than the rule. Because plea bargaining should not be used in a case where it would be the society would be given a message that you can always get away,
can deal
with an offense or cut deals. So yes, that is like I've said, it is not clear cut, but as the ODPP, we are very clear that sexual offenses are not touched.
Children's cases
are not touched. Murder, we will consider
to an extent.
We will consider the circumstances, but it will be an exception rather than the rule.
The rule.
Yes.
Oh, okay. So you had mentioned that you also work in the anti-corruption docket.
Yes.
Does plea bargain apply to anti-corruption?
It does, in fact, because in anti-corruption cases where monies are involved, an accused person may offer to refund the amounts. We don't only consider the amounts you are alleged to have stolen, though. We will also consider the monies or the interest or the profit you've earned from the use of that alleged
So
stolen
you
funds.
have to bring back the profits.
Yes, so we'll ask you to bring back the what I would call the principal, the
Yeah.
amount that you stole,
Yeah.
plus what you may have earned from the amount, plus any interest if there are.
Are you able to actually know how much someone has earned from proceeds of, say, a corruption crime?
Because money is a mathematical concept, you
Yeah.
are likely to make approximations that are likely to be near what you would have earned. Of course, it's a give and take. It's a plea bargaining in the sense that you bargain like you bargain in the market. So we'd say that we expect that 10 million would have earned an interest of this amount, or if you got it into this normal business, it would have earned you profit to this extent. So if you are agreeable, we tell you 10 million in 10 years, we should have earned around 30 million. Are you willing to give us? You'd say, I'm willing to give 25. We say, yeah, we can take 25 million.
I read somewhere that it's this sort of plea bargaining in economic crimes can just raise inequality, because the rich will go ahead and do their corrupt deals, knowing very well they'll come back to the table and get it dealt with,
I think from the ODPP's point of view, we are very alive to Article 27 on equality before the law. And we do not come to it like we are saying those who have the money can give us. But you will find that many times those who are able to pay the 25 million are people who stole the 10 million. Those who are not able to pay it may not have stolen that amount. But even for these people we call the small fish, the omena, who have done smaller offenses, plea bargaining still applies to them. You find a person has been charged, let's say, a domestic violence case that leads to death. A wife stabs the husband as a result of continuous battering or domestic violence. Then the wife is able to plead guilty to a lesser offense of manslaughter. We look at the circumstances and we say that she did not premeditate the killing of the husband. And we say, okay, if you are willing to take manslaughter, we will give you the plea bargain, and then you will plead guilty to it, and we can recommend a sentence to court.
And also it's important to see that plea bargain is not just a way to punish the poor, because everybody says if it's plea bargain, the rich will be able to get out with it. They'll be able to negotiate. They have better lawyers and everything. We are here for everyone. And when it comes to plea bargain, we give you the information regardless of what stature you are in. And we tell you the right way to proceed. We make an offer and we tell you your options. And we also look at the evidence in play. We are able to tell with a case because we make the decision to charge. We only make the decision to charge when we know there's sufficient evidence to proceed with that charge. And then we will come and tell you, we are able to proceed with this charge, but don't you think you should take accountable? You should be accountable for your action. And also, you don't have to go through the whole trial. If you already know that you are willing to take that step forward, it saves a lot of time for the court, because we then proceed with the cases that need to go ahead. It resources for ourselves as ODPP, because we are then able to concentrate on other cases that need to move forward. The victim's time and also their mental state is assisted, because this idea of coming to court every time and you're seeing the person and he's still denying, and yet you saw him do it, it really affects a lot of families and their mental state. And then also for the public at large. If people know that you can come, and if you've done a wrong act, they're able to say, yes, I'm the one who did it. It builds confidence in the justice system. So it's not always that someone can get away with it, or they'll just come to court, they'll take years going round and round, and eventually the witnesses will get fatigued. They will die. People will even just lose interest. But with plea bargain, it encourages justice, as he has said. People are able to see justice as quickly and as efficiently as possible. Which is important.
So just still on the plea bargain and the extent to which you can apply, how on SGBV cases, for example, and on murder, to what extent can plea bargain apply?
Our rules and also the Section 137 is very clear on SGBV. plea bargain does not work on
SGBV, yes. Yeah.
Yes, it doesn't work there because the people who crafted it decided that plea bargain could only work in other cases. It can't work in SGBV. It can't work, I think it's in those kind of things.
Oh, yeah.
They don't apply.
Yeah.
Anything else is applicable depending on the terms, as JB has said. In murder, especially because we are able to look at the evidence at a very early stage,
Yes.
we're able to know basically what kind of decision we can make, and also we can see that this one will be able to proceed with it full and will be able to ensure that that the court is able to get the whole load of evidence and a likelihood of murder is put in place. But the Constitution says, and Constitution and also the Penal Code, murder is, our conviction is death. That is a punishment. And what we tell people is an option if you plead guilty. But remember, when you plead guilty, there are certain constitutional rights that they give up.
Yeah, we'll just get to that in a bit. So investigative agencies do their work, and then you make the decision. The process of, so who initiates the process of a plea bargain? And then at what point can you enter a plea bargain as an accused, of course? And then what influences this choice?
I'll take part one of the question,
one,
then JB can take the other one.
Yes.
So initiation can be done by either party. It can be done by the prosecutor, the accused person's lawyer, and in very rare cases, the victim can come forward and say, why don't we plea bargain? We do this formally in most cases. There has to be a formal offer in writing. And once that is done, what the ODPP does is we review the file and see, is it acceptable? Is it as repugnant to justice? Is it one of the charges or offenses that cannot be used in plea bargain process? And then we also look at what charges we can bring forward. The accused person, or if he has a lawyer, his lawyer.
Yeah. And
we tell them, we've looked at the evidence, this is what we are willing to do.
Yeah, okay. So JV, so at what point do you enter a plea bargain?
The rules and our guidelines are to the effect that you can seek plea bargaining at any time before the accused person is placed on the defense. Anytime.
Anytime.
During the trial. So
Okay.
you just need to indicate to us, or we need to, because, our criminal cases, you are able to see their direction as trial moves.
Yeah.
So you find an accused person who listens to the first, the main witness, normally called by the people as the complainant, although we are the complainants.
Yeah.
And they say, I am doomed, or the advocate advises them,
You're doomed.
from this evidence of this main witness, we are not going anywhere. So in many cases, they may be triggered to now say, what if we offered plea bargaining, what would you give us? Then we would tell them, then in that case, let's see what the other evidence has. Then we see if we can reduce, or we would insist and stick to our tag and say we are proceeding with the main offense. So anytime before you are placed on your defense.
Okay. So on what basis can the court reject a plea bargain?
The court's acceptance or refusal of a plea bargaining is a discretional power. The court has that power, but as is the exercise of any discretion, it has to be within the law. Even the courts are bound by the law. So if the court finds that parties entered into an agreement that is contrary to the law, like the prosecutor and the accused person were guided by other considerations than the law, it's not supported by the law, so no. If the court finds that it is repugnant to justice again, it is against the interest of justice, against the fair administration of the criminal justice. The interest of the criminal justice is that an accused person should be held accountable for their offenses, and at the same time, the victim should get justice. So if it is going not to give the victim or ensure justice for the victim, then the court again would say no. If the recommendation that the parties are giving, for example, the terms and conditions the ODPP is giving is contrary to the Bill of Rights of the accused person, again the court would say no. Because an accused person may be fearful and may enter into a plea bargaining because
out of fear.
They are fearful or they just threatened. Then the court is there now to ensure that their Bill of Rights except those rights that they willfully give away, like the right to presumption of innocence because they are pleaded guilty, and the right to a full trial. The rest of them, the court will ensure that they are protected. The other reason why the court may reject a plea bargaining again is where maybe the recommended sentence is unlawful, or it is extremely manifestly too high or manifestly too low in the circumstances.
Okay.
The court would say that for a murder in the circumstances, you cannot recommend 1 day, for example. 30 years.
Oh yeah.
Yes.
Okay.
So you see, the court will either accept the agreement as it is or reject it entirely.
Okay.
Yes.
Yeah. So we took people through the decision to charge. So you make the decision to charge. Can a cop, for example, tell me, Anita, hii kesi tumeona hii evidence, we kubali tumakosa tumalizie hapa. So does it have to go to court for it to be
plea bargain, you must come to court. There must be a charge in court.
Okay.
You must go before a court to plead guilty or not guilty, and the plea bargain must be tabled in court, and it is accepted on the charge that you have negotiated for. There are alternatives to prosecution. There are alternatives to prosecution, like diversion, where from the police station, you have areas where the police officer will see and say, right, this matter looks like a case where we can divert, and he consults with the prosecutor. The prosecutor, of course, will look at the evidence and say, this issue, and given the background, as a child who was involved in doing something in school or stole something from a neighbor, we are able to go back and make sure the community is involved, and rather than take this child through the trial process and conviction, we're able to that if it's a chicken they stole, they can pay it back, they can go for lessons, they can go back to school, those kind of things. So for plea bargain, you must plead guilty to an offense, and there is either a criminal trail or a criminal record that is put in your system. For diversion, you do not have that because you do not go to the end version of court for a conviction.
Okay, we'll get to discuss diversion later on, not today, but thanks for bringing that up. So we've talked about different players and actors in this plea bargain process, and I just want you to take me through a bit of that. Maybe, JV, there's a victim. Does the victim have any rights, a say in this plea bargain? Can the victim say no?
Yes. Actually, the Protection Act, which ensures that they are part of the journey, the entire journey. Right from the time you decide to accept an offer or give an offer to an accused person, you must inform the victim both of their rights and of the possible effect of accepting the plea. So you will also have to take the views of the victim, whether or not they are agreeable to such a plea bargain and a plea negotiation or plea bargain. And although we do that, because the ODPP is a gatekeeper of the criminal justice system, we are supposed to consider, actually consult with the victims, hear them out, hear their views, consider their views, but we are not bound by those views. So that you will find that we have, after considering the evidence and the entire circumstances, felt that it is in the interest of justice that we accept a plea offer from an accused person. But many times it takes some victims time to heal, to accept that this really happened to them, and they think that a plea bargaining would be denying them justice. It is our duty to explain to them to understand, but it is not we are not bound by their refusal. In the reverse as well, there may be circumstances where there is collusion between an accused person and a victim. And I know that has been
seen recently, actually.
Where the victim actually is the one who comes and says, we have agreed. It is still the duty of the ODPP to consider the circumstances of that agreement between the victim and the accused, and see if it would be in the interest of justice to actually allow a plea bargaining. If it is not, despite their agreement, we will say no, because it is our obligation to ensure the fair administration of the criminal justice system.
Good, interesting. So the victim, it's not victim hostile. it considers a victim all the way.
Actually, it is compulsory that you consider
The victim.
Yes.
Good. That's very good to know. So yeah.
And I was saying, and also when it comes to the victim, you must also be prepared to understand that they're the ones who have felt this injury, and you need to be able.
Aggrieved.
Yes, they're the ones who are aggrieved.
Yeah.
Well, we are the complainant as a republic. We also need to acknowledge that these people have been aggrieved at such a personal level. Not to include them in this kind of process is to leave them out in the cold.
It's not justice.
It's not justice. And our constitution and even our act and everything that we do is all around that concept of justice. How do we bring in as many people as possible? And how do we ensure that once we have finalized our plea bargain, everyone is able to, first of all, they don't have to be satisfied, but they know what the process has been like, and they're satisfied that it was fair and with integrity.
Okay. Just to add on the issue of the victims, one of the terms and conditions that we may normally include in the plea bargaining is compensation for the victim. So that even though this accused person may make amends in other ways, there may also be a clause in the agreement saying that the accused shall compensate the victim for the loss, what we call restitution in restorative justice. So plea bargaining is a way of moving from retributive justice, which is the order before 2010 Constitution, to restorative justice, where the parties are supposed to come and find
so it's restorative in a way.
Yes.
Okay, that's interesting. We have some questions online, so I'm just going to ask a few as we still go through our discussion. So Esther Chebet asks, would you recommend plea bargain in a murder case where the deceased was a young child, let's say was under 10 years?
It really depends on the circumstances. We usually would not want to make a decision unless we know all the facts that are in play. Plea bargain is acceptable is applicable in murder cases. You're able to enter plea bargains in murder cases. And as we've discussed here, it all depends on the circumstances in play and what role the accused person played. Was it a relative? Was it a stranger? Was it a neighbor? Those kind of things come into play. And we also ask for a probation report so that we're able to look at what the victim's family is saying and what the accused person is saying. So it's not very easy just to say yes or no. The circumstances will guide us.
Okay.
But it's open for all murder cases.
It's open. All right. And then Mumbi Reri is asking, is consent of deceased family necessary?
I think what Mumbi is asking is whether or not, because the deceased family are the victims now, whether or not they are considered. Like we've said, we will consider their views, but the views are not binding. But we must give reasons for disagreeing and or agreeing with their views. Especially where we disagree with the views, there have to be reasons that we have considered your views on this, your permission or refusal to give us permission. But in the circumstances of this case, looking at the entirety of the evidence and the circumstances, we think that plea bargaining would be in the interest of the interest and the public interest. Yes.
Okay. So there's comments, a lot of discussion here. So Gilbert Wanami says, I have incidences where a plea bargaining is initiated in a murder case. The case is then taken to a lower court for a plea of manslaughter. On reaching the lower court, the accused person pleads not guilty. Then the case proceeds to a full trial on an offense of manslaughter. Is this the position, or should it proceed to a full trial on murder?
What happens is, if you have originally been charged with an offense of murder, the plea bargain is to lower the sentence to manslaughter. If the plea agreement, I said, if the accused person refuses to answer to it at the end of this being fraud, or there's another issue, the original charge comes back into play. Because the only reason that you have the plea agreement and the plea bargain is because you agreed to plead to a lower offense, which is manslaughter. That is the only thing that you can plead within that plea agreement. If you say no to that plea agreement at manslaughter, it reverts back to the original, which is you proceed with the case of murder. And that's why in most cases, the plea agreement is before the High Court, the court which originally took the plea of murder. So that if there's a problem, and if the accused person wants to reject it, you are told then proceed with the original offense, which was murder.
That's being slided.
Sorry. Maybe just to add one more thing and say, It's a little difficult to have a situation where you are plea bargaining from murder to manslaughter, have the file go back to the lower court for a trial.
Yes.
Because one of the conditions, and the very essential condition of plea bargaining, is the plea of guilty. You have to accept that you committed the offense. So what happens generally in our law, in our courts, in the high courts, is we will charge you with murder in the high court.
Yeah.
As a result of plea bargaining, you have indicated as part of the agreement that you are going to plead guilty to the lesser offense of manslaughter. The High Court has original jurisdiction for all offenses. In fact, the High Court can even try stealing cases. So there's no need for us to go back
to the lower court.
We will draft fresh manslaughter charges, take it before that same High Court for you to plead guilty there and then.
Okay.
So there's no way we are going to take you.
So you can't be crafty about it, because I think he's talking about a crafty person.
I think what he's talking about is where the decision to charge with murder has been reviewed. And the revision, because as prosecutors and under our decision to charge, we are obligated to constantly review our cases. Yes. So in some circumstances, they're able to review and say the position that we originally charged with murder, something has changed. And in that case, we are able to review our decision from. If we are now charging you with manslaughter, it goes back to the lower court for a trial. Plea bargain. We've actually just reviewed our decision to charge under our policy documents, and we believe that now we can proceed with the manslaughter charge in the lower court. So it's not crafty that you'll come and try to pull the case from the high court and then take it to the lower court and then somehow refuse to plead. No, that doesn't happen.
I think it's trying to you are charged with murder, and then you go make a plea. You get manslaughter, and then you're like, so I think it's trying to think like me. I'd think, let me change this to manslaughter, then I go back.
It's impossible.
Impossible. Yeah. Interesting. I think, thank you guys for your comments and for watching and for your engagement. I will try and answer questions that have been raised here. So there's Gloria Ongubo, who says, when you plea bargain in murder to manslaughter, the case is not taken to the lower court. No, I think she's
answering.
She's responding, yeah. So Clement Okech says, the ideal and the correct procedure in calling for a pre-sentence report from probation officers in plea agreement process is to have it after the accused pleads guilty and not before. I think, again, it's in response, yeah, to that guy. So in cases where a minor is charged with murder, what factors will be taken into account with regard to initiating a plea bargain process? Does it involve? This is from Byron Menezes.
We have a few cases, especially young girls and young boys who have gotten themselves into trouble, which then ends up to murder. Yeah. Mostly it's those ones where it's a boyfriend, girlfriend, it's a neighbor,
Romeo and Juliet.
Kind of things.
Yeah.
And in those circumstances, while we do charge with murder, we look and see how we can initiate plea bargain at a very early stage, depending on the circumstances. And when we are dealing with with a child who's now the accused in our case, we involve a lot of parties. We involve the children's officer as early as possible, the children's representative, is it a guardian, is it an uncle, an auntie, whoever is responsible for that person. And we also look at the history of that child. Do they go to school? Is there been a problem at home? And how can we ensure we make sure that the child takes responsibility for their action. They're also not shunned by the society. We still want them to go back into the society because they're a child. Yeah. We don't want them to have this kind of issue.
Tag on them.
Yes, tag on them that they're not even able to proceed with their lives. We make sure that they go for mental health issues, family counseling, all those things to make sure that, yes, you have done something that is really, really wrong, but we want to get you back on the right track. So as you are saying, we involve a lot of parties. Yeah. The court is very sensitive to these cases also. And in fact, when we are doing children's cases, in most cases, we do it in privacy. So they're able to respond without a lot of people involved.
Without the pressure.
Allow me to add. And if you also allow me to send a shout out to Byron.
Oh, awesome. Okay.
This question is what are the factors we may consider? I think one of the other factors we would consider, and I know Senior agrees, is the best interest of that child. What would be in the best interest of the child? I think the greatest interest of a child, depending on the age, let's say between 15 to 17, is the rehabilitation of that child. So many times I am of the view, which I think many of us share, that the criminal trial is not the best way to rehabilitate
A child.
The judiciary, the courts have previously held that even having a conviction, a record of conviction on children is against their development and rehabilitation and growth.
Yeah.
So apart from the interest of the child, the need to rehabilitate, look at in what circumstances did the child kill the other. Was it a game because children they were playing dangerous games without the intention to hurt, or was it a clear-cut situation like I had a murder case in Busia where one child just took a stone and
hit the other.
I also had another where one child, they were swimming and was trying to see how long the other could be underwater.
Oh, no.
So you see, these dangerous games,
Yeah.
this is not a person who premeditated the death. So we look at the circumstances and also the need to have this child
Rehabilitated.
Yes.
Okay. So we were talking about the actors before we went to the questions. And I think one of the main actors are the defense lawyers. So someone can argue that if we don't go to a full trial, then you deny me a chance to earn my keep.
That would then be a good lawyer. The lawyers also are very aware of what role they play in the criminal justice system. And they're there to make sure that they represent, to the best of their abilities, their clients' needs. So a lawyer will tell you that, oh, I would have wanted to go through the whole trial process to earn my fees, does not really, first of all, understand his case, and is not actually looking out for his client. Because plea bargain is a way that you actually remove your client as quickly as possible from the criminal justice system. Because you look at the evidence in play, you tell them here, if you go forward, you'll probably be, so we'll be in court every other day. And then at the end of it, you'll still be found guilty, and your punishment is A, B, C, D. Why don't you look at the circumstances and we go and offer a plea? And remember, a plea offer is just an offer. You want to hear what we have to say. We'll tell you the circumstances and what we have to say, and the accused person and defense counsel will then meet and agree. But defense counsels have become one of our greatest partners right now.
Oh, good.
Because they understand what's going on. We've started making sure that we are involved in a lot of LSK things, although we want to be involved in more. When we do our sensitizations, we make sure that there's a slot for LSK and the normal defense lawyers we run into in court, because we know them. We have pamphlets, we have documents that we give them, and we encourage them, if you don't know, ask and we'll assist.
Okay, so that means even investigative agencies are on board this because of evidence and witnesses and stuff like that, because you can go wrong if they go wrong, right?
In fact, investigative agencies, the police are basically our main partner in all this. Because the case starts with them, how the evidence is collected, chain of custody, how it is packaged, and the file turned over to us. So in our rules and in our guidelines, those are one of the agencies that we must consult. We let them know that this is what we are doing, and also they might have other information that we are not privy to. They might be able to say, in fact, this guy has 4 more cases. You know, when you look at a guy who has 4 more cases of robbery, violence, or murder, you'll be able to say there must be a problem. How do we enter a plea agreement? Are we going to enter in all of them or just one of them? So the information they have will actually help us make our decision properly. But as we have said in regard to victims and everybody else, we are the people who make the last decision. Discretion is ours in consultation with our partners.
So power to the prosecutor.
On the defense counsel, I think I would be challenging senior here as the management of the ODPP. I think it's time we took up a partnership with the LSK to especially on
CPDs,
continuous professional development. These trainings for continuous training for lawyers. Not just the defense counsel, but also for luckily we now have the prosecution training institute where we expect our prosecutors will be taken through refresher courses on the various policy documents, including plea bargaining guidelines and rules that we have. And now the partnership between ODPP and LSK would also help us to bring the defense counsels to the same page, where they also understand where is it that the ODPP is coming from and how can they improve the criminal justice system by way of learning these plea bargaining rules.
Okay, interesting. We'll just talk about the bail, how bail works in a minute, but somebody here says, I think it's Clement, we didn't answer his question. As it stands now, there is no clear legal mandate for a probation officer to file a plea bargain report, right? Other than a pre-sentence report, not in law, not in the regulation. So somebody says, please answer Clement's question on the legal mandate of probation officers in filing plea bargain reports.
I think to answer Clement, there is no legal document called plea bargain report. The courts are empowered to ask probation officers to bring reports, whether you call them probation officers report, whether you want to call them victim impact assessment reports, whether you want to call them, what's the other word that they have used?
Plea bargain report.
Plea bargain report.
Yes.
This report is basically a social impact report, the social background report on either the accused person and the victim's family. Just telling the court, these are the facts. We went to the families, we found these positions. It helps the court. These reports are not binding on the court. It just helps the court to reach an informed decision. So I do not think that there would be a necessity, if I get Clement, if that is the suggestion, that we put this into law. We already have enough laws, and the courts are properly empowered to call for reports from probation officers, from children officers, to help them make informed decisions. Yes.
Okay. There's a question here, and I think this is just what happens commonly. So if someone is found with someone's wife and he struggles and later on be killed by the husband to that wife, is it murder or manslaughter? So clearly we need to maybe to some extent define what manslaughter is and what is murder.
Murder is the main difference between the two is malice aforethought. Malice aforethought is you had that intention, and it's a foreseeable intention to actually kill that person. So in murder, we say we will charge you with murder because you could foresee that your action would have led to the death of this person. That means you could have stopped, could have taken a step back, but intentionally proceeded to do that action. Manslaughter is where you did not intend to kill that person. Probably something went wrong and you ended up killing that person, but it was not foreseeable for you to actually say, I want to kill that person. So this regard for wives and husbands in people's houses, we have very many of those ones. And the first of all, the circumstances we'll see is who found who in the house, what were they doing, how did you kill this person, and what was your actions leading up to this thing. Because normally it's you already can foretell that I'm going to find so and so in the house, and then we are going to fight, and then we are going to and you can foresee what the end result is going to be. But in most cases like those ones, we tell them plea bargain. Come and plea bargain so we can lower it to manslaughter. But you had the malice aforethought. You knew that your action was most likely going to lead to this person's death. Yes, you must accept that you knew that your action was most likely going to lead to the death of this person. And knowing that, you still took the position that you are going to proceed with this action. So, when someone takes a knife and starts threatening you with it, they already know at the end that I'm going to stab you.
There's an outcome,
And that's when they stab you along this torso, somewhere where you know that the likelihood of you surviving is very low. You had the malice to continue with that action. So you must also take accountability. You can't say, I found my wife and I was angry, therefore I should not be held accountable. It's someone's life. Regardless of what those other two are doing, that victim had a family of their own.
So in accepting, continue.
If you allow me, it has reminded me of a very interesting case again in Busia. This was by Justice Triot. This gentleman was suspecting the wife to be going out with another man in the village, in one of those villages in Busia. Every evening the wife would be going to the market, but she would take longer than the man thought was sufficient to come back with food. So he started following the wife every evening. So one day he gets to see the wife branch into a bush, and he waits to see. So he gets closer to the bush, and then he sees that the wife gets the lasso, spreads it, then they get into the act with another man. So he stoned this, he left the wife running, but he stoned this guy to death by just stoning him. So he was arrested and we charged him with murder. And then when we charged him with murder, we thought that it was very obvious. Then we went through trial, and the court, Justice Triot, found that the proper offense he was convicted of was manslaughter, for reasons that the court said there is nothing more painful than finding your wife
Yeah.
in the act,
Yeah.
which in Latin is
Oh,
in the act.
okay,
In
okay.
the act.
Yeah.
So he said, for that you lose your mental capacity
Yes.
to even think, and so that which senior calls malice aforethought is missing, and therefore as a result he therefore convicted to manslaughter. So the difference from that question mainly is, away from the legal terms, is that it also depends on the amount of force you use. If you attack a person with an intention not just to kill them, but also to cause them grievous harm. Grievous harm are those kinds of harms that lead to permanent
like disability and scars. Yeah.
You know. So if your intention was to cause grievous harm, but it leads to death. That is still murder.
Oh.
Even if you didn't intend to kill them, but you intended to cause them, in section 206, the court comes in and says you still are guilty of murder. But if you use force that was necessary to defend yourself or property, there is the aspect of self-defense. That aspect of self-defense in law is called total defense. It takes away the malice. Malice aforethought. The intention to kill. Okay. If you attacked me in my house and you were going to cut me, I had real apprehension that you're going to cut and kill me, and I kill you first, that is in self-defense.
Yes.
But if you attacked me and I was able to overpower you, and then I chased you for, say, 500 meters, when I had the opportunity to calm down, then that still now would be murder.
Yeah.
Because you had the opportunity to ease off,
take a step back.
Took advantage and killed. Yes.
Oh, interesting. So in going from murder to manslaughter, you are saying you will not be given the mandatory sentence. You'll be given a lesser charge.
Because the sentence for murder is death.
Yes.
That is what is in our constitution and in our laws. But the sentence for manslaughter is discretionary to the court. It can be anything from probation all the way to life imprisonment.
Yeah.
So given the circumstances of those pre-bail reports that the court orders, the court is able to look at the issues, and with the sentencing that prosecution does and the defense counsel look and see what sentence is best to rehabilitate this person. Yes.
Oh, okay. So we've talked about SGBV, murder and corruption cases, but does plea bargaining apply to petty offenders, like traffic? Like if I'm caught on a traffic offense, can I say, oh man, I know I'm wrong, I jumped light, man, just let me go, or tell me what I need to do to not go to court? Because most of the time we find people go to court for petty offenses, like traffic. You'll be told, we utaenda Monday, utaenda kotini Monday, we ngoje uende kotini. So you find a lot of, and I think the main aim of plea bargaining, like you said, is to decongest the system. But petty offenders still congest the system. So how does this work? How does the bail system work? If I can't afford bail, if I'm caught loitering at night, I can't afford bail or cash bail, whatever it is you're given, then I'm still taken to the system. So how does a bail system work? Does it put pressure on plea bargaining? I mean, how does it work?
I think you've raised two issues.
Yeah.
You've raised the issue of whether plea bargaining applies
to petty offenders. Yes.
You've also raised the issue of relationship between bail
and plea bargaining. Yes, thank you.
I don't know which one, Celia, you want to take.
Maybe I'll take bail.
Yes.
And it applies to all offenses. And the process of bail is there are two concepts of bail. You can be given a police bond. This is where the police finds you, instead of keeping you in the cells, you give them a certain amount of money depending on what the likely offense is.
For which they give you a receipt.
That one lasts. Yes. And then they tell you, this matter will be in court on this and this day. Come and you'll get back your bond money.
Yes.
Before you actually proceed to plead guilty or through the court system.
Yeah.
Then there's the other concept for now court bail. This is where you've been brought to court, you've been charged with another offense, you've pleaded not guilty, and now because every offense is bailable, you apply to the court and say, I want to be bailed.
Yes.
And The accused, now the prosecution is the one who says why you shouldn't be acceptable to bail. Are there some circumstances that the court will need to consider, that if letting you go out on bail, you'll interfere with the witnesses, you won't come to court, you'll get out of the jurisdiction, or you'll damage some evidence that is critical for our case. So those are the issues that between now police bond and court bail.
Yeah.
Court bail is determined by the court. It's at the discretion of the court. One has to seek it, and the prosecution now can make a decision. Are we actually going to say that, yes, we want you to get out on bail, but on certain circumstances. And that is what allows you to get out on bail.
Okay. So do I have to go to court for a traffic offense?
You do not have to go to court for a traffic offense unless the circumstances dictate that you do. But say that the understanding that because plea bargaining helps to decongest courts, and bail also helps to decongest courts. Maybe let me start with the relationship between bail and plea bargaining.
Yeah.
Where the prosecutor and the accused persons have started or initiated plea negotiations, where we have a likelihood of entering a plea bargaining agreement. Because everyone, like Sina says, is entitled to bail. We can then tell court that we can see there is a high likelihood that we are going to enter a plea agreement.
Yeah.
We would therefore our opposition to bail, because you will only be denied bail if the prosecution opposes your release on bail.
Okay.
So we can say, as part of our showing good faith, we are withdrawing our opposition to bail. He may now be released on bail, pending our negotiation of the plea agreement. So bail would then help to plea negotiations and agreement. For petty offenses, I think the best tool to deal with petty offenses would not be plea bargaining per se, although plea bargaining would still apply to petty offenses. The best tool to deal with petty offenses would be what Senior discussed as diversion.
Oh yeah.
Say that these petty traffic offenses, why do we need to even waste judicial? How about we find better ways of holding them accountable? Take them to, you saw the other day the courts had taken some
the community service. That was diversion.
Yes, that is diversion. Or the court says that this is a past offender of a traffic offense, and the court decides to discharge you. You are guilty, but you are discharged under Section 35 unconditional discharge. Just go home. You were given an explanation. You are rushing your wife to your pregnant wife to hospital.
And then
But we're also thinking of ways, like in the US, where the prosecution is given some little bit more powers to be able to divert cases internally and say, where children are involved, we ask the children to, through the children department and counseling and guidance, they go for this therapy, petty drug use, e-bangi, go for counseling and do that for the next 6 months. Then once you are able to prove that you've gone through the process, we will then divert. We will not charge you. So diversion would help with these petty offenses more than plea bargaining would. But if you had, let's say, 10, or let's say for a picky border rider, you do not have license, you do not have a helmet, you do not have the jacket, which is the other one?
You are drunk.
You are drunk. So you have 4 offenses, and you are willing to plead guilty to not having a license. We would say, let's plead again. We will withdraw the drunk and disorderly. We will withdraw the jacket and maybe charge you for the license and the helmet. So plea bargaining shall have worked in a petty offense. Yes.
I think I asked this because a lot of like in the informal settlements, like in the slums, there's always this thing in the air that mtashikwa na polisi kama kerende, kama group, and then you're all taken in, and then you're forced to plead guilty to whatever offense they put on you. And then you hear mothers saying, my son has been in jail for the last 6 months. What happens? Does diversion work here? Is it plea bargain?
What I've understood you to say is that people have been arrested and they go to court and they plead guilty.
Yes.
Now, when you're pleading guilty, first of all, no one can force you to plead guilty. It is on your own motion that you plead guilty. No, but remember, it's it's still you who's pleading guilty. There are maybe other circumstances that play around with it. But once you do a plea of guilty in court, the court then has to sentence you. Because they don't know your other circumstances. You have just pleaded guilty. So the court will say, fine, a fine of 20,000 or 3 months in jail. That's when you hear the ladies in the informal sector saying, my son has been in jail for 3 months. He pleaded guilty. I don't know what's happening. It's because they cannot afford the fine. And if you cannot afford the fine, you must then continue with the sentence that you've been given. That's why one of the things we are doing is talking to people about what the court process is like. And also the liability that you incur when you plead guilty. Once you plead guilty, all the other circumstances are not, you basically limit a lot of things. Because once you plead guilty, we must sentence you according to the law that we have. Yes.
Allow me to add, because I'm a ghetto lawyer.
Oh, you are good. Tell us.
And I witness them a lot, because you see, those of us in the ghetto, first of all, we fear the system.
Yes, you are born fearing the system.
Not just fearing, we hate the system. The system is an enemy. You are born in the ghetto, in the slums. You come up, you are raised knowing that serikali we call them Babylon. So people go to court. First of all, for those who have never been in court, you do not know what's happening. You are anxious. You are fearful. So you will either just say yes because you don't know what's happening, or in the court cells, there are people who will advise you ati wewe umeshikiwa nini? Ati pombe lita 5. Wenda ukubali. Then unluckily or unfortunately for you, unakubali when the court has woken up on the wrong side. The magistrate has woken up nazake. So that is the day a magistrate who has been, you've been told has been discharging people or fining people 1,000, fines you 20,000, and you're like, no, I pleaded guilty because I was told this magistrate normally discharges or fines people 1,000. So you are like, is there a way I can change my plea? So many times in law we say those are pleas that are contestable, but you see the court will not know that you are advised, or you are not able to convince the court that you are advised. So the ODPP has been doing some community outreaches. I think we just been affected by COVID,
but that stopped us.
And luckily my people in Obunga slums were lucky to host the DPP and the team, where they were told, this is what you should do when you are arrested. And for these other offenses, you can engage plea bargaining. For these ones, we can engage diversion. And for those where families raised, and I know the DPP is still able to do that now, you find a lady saying that my child has been in prison for 12 months. There was a case where their child had been in 12 months for a very petty offense, while the Constitution says that a person should not even be incarcerated or put in the cells for an offense whose punishment is not more than 6 months. But this is an offense which is punishment is less than 6 months. You've been in custody for 12 months because the trial is so slow because our courts are clogged, and that's why plea bargaining helps congest our courts. Yes.
Okay, interesting. I hope what Waslamu wamesikia. But I think it calls for continuous engagement and education.
Yes.
Because sometimes when you see the policeman, everything goes off. You don't know what to do.
But that's why, as you say, it's important to educate people on their rights and also what the criminal justice system is about. Not we know it very well because we are prosecutors. You're getting to know it because you're interveners. But the ordinary man on the street does not know what to say when you go to a police station, what to do, what the offenses are. Even in court, people are so scared. Even well-educated people, the minute they go before a court, things change. And they whisper and they say, oh, maybe this. And you're telling them, this is what you should do in the court system. Because the court is not your enemy. And although we like saying the police officers are bad, evil, all those stories, they're actually your brothers and sisters and uncles.
When they're in uniform, they can be really scared.
No, these are still your brothers and sisters and uncles. Yes, they're always bad seeds, but that is the exception, not the rule.
Especially in the ghettos, they come with what we used to call the Mariam, the lorry.
Yes, you see that.
And people just run.
You have just
the direction you're running, you fall onto a police officer.
And they take you.
So things are changing, but in the ghettos, though, it is very scary.
It is,
The police and the wananchi there are like
It's cut Tom and Jerry.
Yes,
Tom and Jerry then after
Yeah.
So it's changing though, and that's why we must take advantage of this platform.
Yes.
Just to inform the people again, by the way, that one of the things that the ODPP does is to review cases. Review. So if you think that your case is one that merits review, just go to the nearest ODPP office. I think we are in all the counties.
All the counties.
Almost all the sub counties.
Yes.
Or just come to send a message to the headquarters, and the ODPP
You'll respond.
will always have a way of looking at each and every file depending on its own circumstances.
Yeah. Maybe it's also fair to just mention that you're the ministers of justice and you're here for public
we
interest.
actually the gatekeepers of the criminal justice
Yeah.
system. So our main role is to ensure that justice is done, and not that people cannot spend unnecessary times on they should not.
Yeah. Okay. So we talked about this being a very voluntary process, but to what extent is it voluntary? I mean, does the quick win advantage of plea bargain compromise the voluntariness of it?
No, when we enter into a plea agreement, we inform you of your rights and your right to actually refuse the plea agreement, even in court after we have gone through the process. You still have a right to say.
You can still say.
At the court stage, you can still say, no, I don't want to do it. And we will withdraw it and we'll proceed with the trial. So it is your right at all the stages until it is signed to say no. And then when you talk about the quick wins, it's not only a quick win for other people, it's also a quick win for the accused person. They spend less time in court. As I said, they take accountability for their action. They make peace with the community. The people who saw him do it, he's able to say, nilikubali, compensation, as JV said it, if there's a clause of compensation, you're able to put it. And he or she is able to move on with their lives, knowing what action they've taken. So this quick win is not an illegal thing that we are trying to tell you to do to do a plea agreement. We want you to do a plea agreement with all the information. Because if we look like the plea agreement has been entered through fraud or misconduct on our part, it fails. And the court would tell us, you people have a higher duty than anyone else in this circle. You are the one who's supposed to make sure that everything that you do is done with the interest of the accused person in mind and to promote the integrity of the court. When in the court process, when you are undergoing the plea agreement, the court still goes through the process. It asks you, what did anyone force you to enter this agreement? Do you know what rights you are giving up? You're giving up on?
Maybe speak to that a bit. So what rights are you giving up when you get into a plea agreement?
A plea agreement, first of all, you're pleading guilty. So as JV had said, you're giving up the right to a full trial. You're giving up the right to appeal any conviction that has been given to you, and you're also giving up the right to be seen as not guilty until proven. So these are those fundamental rights of the accused person that you are giving up on. In most cases, what people do, like when you plead guilty in court, you plead guilty and then you say, oh no, I'm not understanding, I want to appeal. But you'll be told, you pleaded guilty on your own motion. How are you going to appeal? Unless now you say, I didn't understand what I was being told. But for plea agreement, we take you through the step so that you understand what you're pleading guilty to and what now your rights are. So that it's very rare for a plea agreement to be challenged in a higher court if you have gone through all the steps that are necessary.
Okay, can you still get a mandatory sentence after, because it's at the discretion of the court still? Can the court still just give you the mandatory despite you?
Discretion is their sentencing guidelines, which guide them when making a sentence. And in most cases, they won't give you the mandatory.
Okay.
Yes, if it's manslaughter, you have a wide discretion. They'll decide, depending on the circumstances, the pre-bail report they've been given, the victim impact statement, they'll see which sentence to give you. But it's not...
Rarely will they go the mandatory.
According to their own sentencing guidelines.
Okay.
Yes, I wanted to add on the quick win. You see, because it's a bargain, it's just like in the market. Everybody is trying to get value for their bargain. So an accused person involved in plea bargaining will definitely get a better bargain than if they didn't get the plea bargain. Or they should at least get a better bargain than if they didn't go for the plea bargain. For example, if you don't enter into the plea bargain, like Koi said, before we get into the plea bargain, we have considered the evidence and we are sure that it is sufficient with a reasonable prospect we know that if we go full trial, wewe unafungwa. So we are offering you at this point because we are sure the evidence can lead to conviction. So if you accept the bargain, then it means you will not be going through the entire process just to be convicted. You are getting a lesser offense. Lesser offense means lesser sentence. On the issue of mandatory sentences, it's a discussion that one of those greatest discussions we're having in the criminal justice currently, where the Supreme Court said that no offense now has a minimum mandatory.
Is that the
Muratetu case? Yes.
We learn.
We can say you're learning.
Yes.
So the effect of the Muratetu case is that even for murder now, which carries the maximum of death, you can still get
life,
a determinable sentence. You can even get 10 years for murder currently from Muratetu. So what plea bargaining gives you is that instead of getting murder to sentence you up to death, you can get manslaughter, where the court can sentence or even discharge you. You heard about the uproar in the 1-day sentence.
Yes, and I wish you could talk about it for a while. The Siaya case.
Yes, I have my own reservations with that decision. Although I already told you about the Lucia case of the stoning. The stoning case, Justice Tuyot, having found him guilty of manslaughter, released him immediately. Been in prison for the last 6 months.
Okay.
But for the Siaya case, this lady had been in prison for just 1 month. 1 month. And she was sentenced to 1 day in prison. And she was given fare back home. You know, I felt that giving such a person fare back home sends some very confusing message.
But the background of the case, JV, was quite different. She was abused for all her life.
That's a matter that the court has made a finding on the fact. Although I have issues with it, because just like the court said, this lady, had she been killed, she would not be here to tell her story. It's the same way this gentleman who had been killed was not there to tell, but we are not disputing that. I'm just saying that even for the courts, when you give a sentence, that sentence should be able to be proportionate to the circumstances. There are cases where a person can be set free immediately, depending on the circumstances, including how long the person has been in custody during trial or during plea bargaining. There are cases where plea bargaining and you get manslaughter, you still deserve to get 10 years. So it is a matter of the circumstances of the case. So basically what I was saying is that plea bargaining is a better place for an accused person than it is without plea bargaining. It is also for the prosecution because it saves us time. We also are able to dispense justice expeditiously, and we are also now able to use these resources elsewhere. By COI.
It's good you've mentioned the prosecutors. You're also human. You can have your prejudices and your unconscious biases. Are there guidelines that work under this?
We have various guidelines. We start with the National Prosecution Policy that guides us in how we conduct ourselves as prosecutors. We have the Code of Conduct for Prosecutors that talks about how we carry ourselves and how we conduct ourselves. We go to decision to charge. This is how, when we are making a decision, the process we must take, the consultations we must do with our supervisors and all those other issues. And then for plea bargain, we have the plea bargain rules and we have the plea bargain guidelines that guide us. So there are very many documents that guide us in how we make our decisions.
So it's not at your own whim or it's not individualized.
Although we have the discretion, our discretion is very tightly ringed.
It's guided.
Yes, we're able to look, for every discretion we have a justification of it in one of our guidelines, in our rules, or in our policies.
Of course, the Constitution
and the Constitution.
The ODPP Act. And you just failed to mention that you and I were actively involved in the formation of the plea bargaining guidelines and rules.
You are the one.
But we say...
you have to say these things. So question again, does public interest count? You see, like the Siaya case, if there's a plea has been entered and there's a huge public outcry, do you go back and discuss this thing or renegotiate this plea?
Public interest is at the heart of everything that happens in the ODPP by dint of Article 157.11. everything we do must be in the public interest. But public interest is not synonymous with the interest of the public. It is not what the masses want. Public would be in the
best interest.
The best interest of the society.
Yeah.
You know, so that and public interest is a factor that is considered at the start.
Yeah.
You can't say that now public interest comes after there has been.
Yeah.
So before we enter into plea bargaining, we must consider the public interest. Is it in the public interest that a person who stole 20 million is willing to refund the 20 million plus another 10 million on top, plus compensate the institution from which he stole the funds?
Yeah.
Would it be in the public interest? Yes. If that money would then be used to get medication for COVID, beds, ICU, you know.
Yeah.
So the public interest is a basic, most important factor at the very start of the process of plea bargaining.
I think somebody asked a question before. So there's this plea bargain report. Is it public information?
What is public information now is a plea bargain agreement.
Okay.
That is what is filed in court, and that is a public document that is in court. Remember, everything that is filed in court, depending on what kind of case it is, are public records. So someone can go and ask to see it.
Okay.
But the reports that are filed in the probation reports, the children reports, those are kept, those are a bit more private.
Okay.
Because we have these details of what the family members said, what the recommendations are. So those ones are not really public for anyone to walk in and see. But the plea agreement is a public document once it's filed in court.
And it is kept in court, not at the ODPP?
No.
Of course we have our copy.
You have your copy,
Yes.
but should I, as a member of public, want to see it, then I go to the courts?
No, we are a public office guided by the Constitution, including Article 35 on right to access to information. So a member of the public can give notice that they want this information. But you see, with Article 35 on the right to access of information also comes Article 31 on the right to privacy. So that's where Koi is saying all these documents and negotiations we use during plea negotiation, just before an agreement is signed, we will consider on the basic plea negotiation whether this is private information that should not be divulged, and then we can write back and say, although you requested for this information under Article 35, the Constitution also protects the right to privacy of this party under Article 31. That is where, for example, the plea negotiation do not lead to an agreement. But if it leads to an agreement, then we can say the agreement, because it is also filed in court, is a public document which we can avail, but we shall not avail this other information. Or we could still redact. We can give you a document and redact and say that the redacted parts are private information that cannot be given without infringing on Article 31 on the right of privacy.
Okay. So then in anti-corruption, because corruption is a big thing, are you discussing this a lot, plea bargaining in corruption cases? Is it working?
Yes, I think plea bargaining has become more frequent with anti-corruption cases because it's where it involves the refund of stolen monies, compensation, interest. So there are a number of those that we have had. Some of them are in the public domain, including some public officers. So yes, because the nature of anti-corruption cases and economic crimes is that it is one where there are likely to be offers for refund.
For refund. So do I get away with it? I refund everything. Do I still get some punishment for?
You don't get away with it. Apart from the refund, just like we said, every agreement is unique to itself with its terms and conditions. One of the conditions may be that we are going to recommend to court that instead of getting a sentence of up to 20 years, we will recommend 5 years. So we'll give you 5 years.
You still get it.
You get 5 years, but refund the funds to the government. Also compensate any victim that may have been injured.
So it's not a get out of jail card.
It is not a deal cutting mechanism. It is not a way to let criminals go scot-free.
Yeah, okay. So what if, because this is, we are proposing this to the public, right? That let's go the plea bargain route to decongest. So what if people just say, no, we all want to go for, because it's also in the Constitution, I want to go for my trial. What if everybody says that? What will happen to the system? I know you've talked about it quite a few times. What happens to the system when everybody says, hatutaki plea tunaenda?
First of all, a person's right to trial is protected. So if they say they want to go to trial, they should go to trial.
Yeah.
We won't prevent them from doing that. But the downside of it is that we get a lot of people in the criminal justice system, especially in the court process. We have limited resources for all our agencies.
Yeah.
So then you get a lot of people, first of all, who may not be able to afford the bail that has been given. And then at the end of the trial, they are convicted and they cannot afford, if there's a fine, they can still not afford it. And if it's a sentence, they must do that sentence in a prison facility. And if you have so many people coming to the system, because we've done our decision to charge and we are able to satisfy ourselves with the evidence, the likely outcome is a conviction, a fine, or a prison sentence.
Yeah.
So we will be stressing the system a lot. That is why we are encouraging people, plea bargain. You are still going to go through the court system because it's a document that must be presented to court. There'll be a judge or magistrate will ask you questions so that you're protected. And you're able to get, as he has said, you're able to get a better deal out of this process rather than going through the whole system.
Process.
Yes.
Yeah. Okay.
I'm glad it's a what if question. Because many times, if we are able to reach the masses, which I hope we will keep doing, people will realize that the benefits of plea bargaining are very much outweigh the alternative.
Yeah.
So that what if people don't go for plea bargaining? They will lack the chance to get out of the criminal justice system. They will lack the chance, they will miss the chance on an expedited resolution of their case. They will lack the chance to reintegration back to the society. They will lack the chance to remove the anxiety. There's an anxiety that comes with just being in court.
Yeah.
I know people who have to drink in the morning every time they take alcohol in the morning, every time they have a mention or a hearing. Especially my people from home. They say, I have to chat because without chatting. So there's that anxiety. So plea bargaining takes you out of all that and sets you free.
Do you have any statistics of our prison system right now? Like, what are the numbers? And does plea bargaining actually decongest these prisons?
I do not have the numbers. Maybe
I don't have the numbers, but we'll be able to share it with you. But it's authorities are very worried about because their capacity and who they have right now is quite high. I think it's double the numbers. So they are also encouraging use of these alternatives to trial, alternatives to prosecution. Because for them, their job is to rehabilitate. You cannot effectively rehabilitate people when there are so many of them. It's only the people who need to be in that system that should progress to that system. If anyone else can do their sentence when they're out of the prison system, that is better for everyone else. So that only the people who really require to be in that system can be efficiently accommodated and also rehabilitated.
Oh, okay.
Yes.
So I'm wondering, just as we wind up, have there been cases of wrongful plea bargains? I've been arrested for this charge. Evidence, I can't even tell myself. I'm so afraid. I go and say, fine, I'll take a plea. Then one day, years down the line, you find that some evidence has come through, or a witness recants their statement and said, I lied. So this person have you come across such cases? What happens?
That would be very difficult, because one of the things we ensure as part of the plea bargaining process is to just remind the suspects and accused persons of the right to legal representation, so that you are able to bring an advocate with you to help you understand the process. But even without legal representation, we try, like Koya indicated, to break down so that you understand every bit. Where a person just were to plea bargain to please us, or I don't know why they would be, we are able to tell. And the ODPP does not just take plea bargains because
for the sake of it
they have been offered, or because it will help to decongest. look at the public interest and the interest of the fair administration of the criminal justice. And we also are obligated to ensure that it does not lead to abuse. Where we think that, I talk to you, we are bargaining, and I think I am having an unfair higher chance in the bargain, then I would advise you that no, I don't think, because for us to get to the level of plea bargaining, we have reviewed the file.
Yeah.
We are confident that the evidence can help us mount a prosecution that leads to a conviction. So that in itself also should help us to know that this is a case that should not even get to court. So if you find there's no evidence, we will not even get to charging, so we will not even get to plea bargaining.
Oh, okay.
So far, to answer your question, I don't think there has been any single case of abuse of the plea bargaining
process. Okay, so you're coming to the end of this show, and it's been very educating, and I hope people out there have learned something. And I think I read or I heard someone say that in the US, in the developed countries, like 94% of the cases go through this process. Are we seeing that coming to life here in Kenya? Is that what our success ought to look like?
Success is relative, depending on the 94%. Even in the States, there's still problems with how the plea bargain process is undertaken in those countries. For us, we want to make sure that we are walking in the same road and in the same journey, that people are not left behind. That is why we are very focused on doing public engagements, sensitization, bringing people on board, so that everybody knows. You may not be an expert, but at least you know what the process is, and that there's places where you're able to get information. That's why we're also working with a lot of CSOs in the community.
CSOs are community
organizations, giving them this information, telling them, even when you are sitting down with mamas or the youth and everybody, let them know about this, so that even if they get in trouble one day, or someone who they know gets in trouble, that have options, and we know where we can get that information. So it's important that we first of all ensure that people know what options are available for them. And in that process, we'll see a higher intake. Remember, we want people to make informed decisions. And when you consent to something, it must be within the information required.
I keep saying knowledge is power.
So the comparison with the US, just like I say, is a little relative, but luckily I've witnessed the US criminal system. What it does is, for children, they have what is called restorative justice, so that most, if not all of children cases should not go to court unless it is for extremely serious offenses like murder. So that is children cases. They are moving away from, again, retributive to restorative justice for children. Children are to be taken for counseling. Children are to be taken to, these institutions that deal with the children, so that they are taken away arrows of the criminal justice system. For the adults, again, they are involving in what has come to be named progressive prosecution. People are moving away from incarceration. We are moving towards plea bargaining, diversion, deferred prosecution. We are trying to move away from the court and try to settle matters in a manner that still promotes justice, but removes the pressure on the resources of the prosecutors. So we are headed there. Every journey starts with a step. The ODPP, under its very able leadership, has taken the right direction. We just need to keep learning from those comparative areas like the US, and still also involve the public, because without them we are not going to make any headway. And with all the stakeholders, tuko njia mzuri. Ama namna gani?
No, we are proceeding well.
I think we have answered most of the questions. Like I say, we've come to the end of our talk today. It's been very educative and very engaging. Thank you very much. I'll just mention a few people. There's Collins Ruben. Thank you for joining us. Okinyal. Yes, we are live on YouTube. We are not live on YouTube, but Victor Hezekiah, Clement Okich. There's Hassan Abdi. Paimuta asked a question on probation officer, and I think we answered it, but we are going to respond to you, of course, with the team of experts that are out there. Thank you once again. Unless you have a parting shots, anything else you want to say about plea bargain?
Before Senior concludes, shout out to Victor Hezekiah.
Oh, awesome.
That's another friend. And to Senior Hassan Abdi for watching us. We watched him last week as well. telling the public that we are moving away from the era where the criminal justice system was seen as scary and fearful. We are moving towards a criminal justice system that is less of incarceration and towards justice that does not have to involve incarceration. We want more of restorative justice, rehabilitation, and less of retribution.
Yeah.
We still will hold people accountable, not necessarily with this harsh punishment.
Yeah.
Still hold them accountable, hold them responsible for their acts, but ensure that we reintegrate our people back and make sure take advantage of their usefulness.
Yeah.
We need those hours that they are wasting behind. Conclusion, the ghetto lawyer says
I like the you're the ghetto lawyer. Yes.
We'll continue engaging with the ODPP.
Yeah.
And we are operating on an open line system. They can always raise their concerns.
Yes. We're available. Yes.
Yeah. For me, I just want to encourage people to that ODPP is here for them.
Yeah.
It's an institution that looks out for their interests. We have a lot of documents assist us in making our decision, and we want to share those with the public. So if the public is in trouble or there's a situation they want to bring to our attention, there are very many lines they can use. We are on Twitter, we are on Facebook.
Yes.
They can walk in to any sub-county. We're at every sub-county. Any place that there's a court, there's an ODPP officer. So please engage with us, ask for any information. Even if that person can't get it to you, they'll be able to know where to get that information from.
Yeah.
Yes.
Okay. Thank you so much. Thank you everyone for engaging with us on our social platforms. It's been engaging. I hope you've learned something. Education is power. So let us all work on empowering ourselves. And like they say, we want to make the criminal justice system restorative and move away from the retributive nature of punishments that it used to have. Not to say you'll get away with it, but we can discuss your crime and see how best to punish you. Anyway, thank you so much. Have a blessed weekend. Have a good, a blessed Easter for the Christians amongst us, and see you again next week on Friday. God bless.
Happy Easter,
Yes, happy Easter. Thank you so much.